we've got more breaking news coming in from the Supreme Court this time. In terms of the triple talaq hearing which is going on, there's a plea which has been filed which terms the triple talaq act as unconstitutional. The centre has filed an affidavit against the pleas in the Supreme Court and has defended the criminalization of triple talaq. It says that this law is to protect married women, Muslim women's rights, and talaq biddat, which is the existing practice under the Muslim law, is not a sufficient deterrent to avoid the misuse of the triple talaq provision. The centre's affidavit has further stated that divorce by triple talaq continues despite the Supreme Court's order in 2019 which had criminalized triple talaq, and that the Parliament is empowered to make triple talaq an offence. Article 14 cannot be used to enforce negative equality. That was an important point coming in from the centre, that Article 14 cannot be used to enforce negative equality. It cannot be used to enforce a bias. It cannot be used to enforce an injustice. Let me go across to my colleague Harish for more details. Harish, what more details can I add in terms of what is exactly the current suit which the Supreme Court is hearing on triple talaq?
Yes, in fact, it's an old issue. In fact, the importance is that 5.5 years of banning the triple talaq as unconstitutional, manifestly arbitrary, Supreme Court has been hearing a batch of petitions which have criminalized triple talaq. It had provided for a law which had a jail term for 3 years for the man who committed the crime of giving triple talaq. They had said that the issue was that they prescribed. The main issue was that Act prescribed strict punishment without actually fulfilling the objective of protecting women, and there was a provision for maintenance and protection, and just said it's illegal. But this criminalization sends a man to jail. There is no provision for protection or assurance of maintenance. So now the centre has filed a very significant affidavit saying that setting aside a triple talaq practice by Supreme Court did not work as a sufficient deterrent because what triple talaq was reported from different parts of the country, and there was almost 500 to 600 triple talaq every year, even after Supreme Court declared the triple talaq as illegal. Therefore, there is a need for criminalization of criminality, and divorce by triple talaq was reported in different parts of the country.
Okay.
Law brought in to protect the rights of married Muslim women. Centre said, despite Supreme Court setting aside the practice of triple talaq, there have been reports of divorce by way of triple talaq from different parts of the country. It was seen that setting aside triple talaq by Supreme Court has not worked as a sufficient deterrent in bringing down the number of divorces by this practice. Therefore, criminalization was required. Back to you.